Hey everyone, I'm Justin Ware with Manier and Herod. I am here with Matthew Kalin of Travelers, and we're going to chat a little bit about reverse social engineering and the potential coverage for lost or unpaid receivables.
Hi everyone, Matthew Kalin from Travelers. Just a little disclaimer, this presentation is for general information purposes only. It's not legal advice. It's not intended to be comprehensive, and it does not affect any coverage determinations or anything like that in any claim going forward. You can read it on there. I'll give you a minute. Okay.
So, as I believe everyone who's watching this knows, cyber crime scams continue to be on the rise. There's a number of scams that are out there. You have your general computer hacking, you have ransomware, which in general is where someone has breached your system. They have locked up your data and are charging you literally a ransom in order to free up your data. You have phishing schemes, spoofing schemes, data compromise. You can imagine the case of like a doctor's office whose system has been compromised, and now the bad guys have access to medical information, social security numbers, financial information, any number of other private and confidential information. And you have funds transfer fraud, which is commonly where someone impersonates you and instructs your bank to send money to the wrongdoers.
Right. So within that category of bad things that could happen to you arises social engineering fraud. And quite simply, social engineering fraud is really where a bad actor impersonates another person and convinces the victim to, in most cases, transfer funds. It's just really as simple as that. It's just an impersonation scheme. They arise in a variety of different ways, as Justin just told you. The sort of sources of the information necessary for the bad actor to do what they do can be derived from a variety of other bad acts. But in most circumstances, what you find is that the bad actor is pretending to be a vendor of the insured, so someone that the insured owes money to, or another usually high-ranking employee at the insured who has the ability and authority and power to really direct others to transfer funds. It can come in other forms as well. It can be a client of the insured, or there's other language that's similar in various policies. But in my experience, the most prevalent versions of these are where you have an employee being impersonated or a vendor being impersonated. Again, traditional social engineering fraud, which really sort of got its rise in the sort of 12, 13, 14 time period, targets an insured from a coverage perspective, if that's how it's viewed. It's someone that is coming after an insured and trying to convince them, dupe them to transfer funds, quite simply. The most common way it happens is over email, like everything else these days. The insurer is going to receive an email that either provides fraudulent payment instructions for a particular transaction or provides fraudulent payment instructions for future transactions. Again, that's the most common. And coverage, depending on certain conditions or exclusions, is potentially available under what has become a social engineering fraud insuring clause, although carriers call it different things.
So, one of the newer scams that we have started to see is what's sort of colloquially referred to as reverse social engineering. That is where the insured has provided a good or service, and they are owed money for that. However, instead of the insured being directly attacked, so to speak, it's the insured's vendor or client that receives the fraudulent email or fraudulent instruction. And I will say, I'm going to say vendor client here as an undefined term. Various policies define it, and there are specific requirements. So I'm just going to use this more in common parlance. So the fraudulent email going to the vendor or client typically directs that vendor or client to send future payments to an account that is controlled by the wrongdoers. So in that respect, the insured submits a legitimate invoice in most cases, and then that payment for the invoice that is intended for the insured is submitted to the bad guys. So after that occurs, we have that the insured itself has not lost any money that was previously in its possession. There was no, the typical social engineering is you are tricked into pushing your money out the door. That didn't happen here. What it's lost essentially is a receivable. That money that was intended for the insured has gone to an account controlled by the fraudsters. So the insured is left with an open receivable. It provided services or goods for which it has not been paid. Meanwhile, you have the vendor or client saying, well, we thought we were sending money to the right place, so am I supposed to double pay? Or what's our other solution here? So you have both coverage issues and often a business dispute between business partners.
Right. And so now you've got a loss presented to the insured, although it's not money that the insured has transferred. And so you look to the policy for coverage. And one of the threshold questions you always ask in a claim or a coverage situation is, well, is it covered property? Does the policy even insure this particular set of property that's been allegedly lost? And what you'll find in first-party commercial crime policies, here we have the ISO language up, is that covered property is limited to money that the insured owns or leases, or in this case, under the ISO form, that you hold for others, whether or not you're legally liable for the loss of such property. Other forms are going to have different usage of the term legally liable. But in essence, policies are covering the insured's property, sort of colloquially, if that's how you want to look at it. It's money that they own, their own money, or money for which they're holding for others, or for which they are legally liable in some circumstances, not ISO, where they're legally liable before the loss even occurs. So this ownership of property provision, again, is a threshold question. You can talk about whether the insuring agreements are triggered, and we will, but as a threshold matter, you have the first-party commercial crime policy is only going to cover property that fall within this ownership of property condition. It applies to all insuring clauses, and it is a condition precedent to coverage. It is one of the provisions that stands out within a commercial crime policy that emphasizes the first-party nature of the commercial crime policy. So as promised, insuring agreement discussion. Which insuring agreements are implicated and why don't they apply? So again, here's the ISO form. The most common insuring agreements under which coverage is sought are computer fraud, funds transfer fraud, and social engineering fraud, which at least nowadays is mostly provided by endorsement. So the short answer is it doesn't trigger computer fraud or funds transfer fraud typically. Computer fraud, as provided in the policies, is where a bad actor in clandestine fashion transfers funds. It doesn't involve, and often now by definition there are forms where you cannot have the insured's knowledge or consent as part of the transfer, or that it cannot be by an employee or some sort of authorized person. The transfer must be by someone who's not authorized to do it, and they must actually make the transfer themselves. So in a social engineering context, it necessarily requires the duping of an insured employee, so it doesn't fit into the computer fraud definition. Funds transfer fraud is something similar to social engineering in the sense that it is where the bad actor pretends to be the insured and contacts the insured's financial institution to obtain the transfer of funds. Again, it does require a duping of sorts, but in this case, the insured's not even involved. So it's typically not when that situation is going to fall into place. Social engineering fraud is how we described it. Now, reverse social engineering fraud, again, with all of these situations, doesn't fall into those categories. So we already talked about social engineering fraud. It is where the insured receives. The coverage provides coverage where the insured's receiving the communication and the insured transfers the funds. In the reverse social engineering context, you're talking about the insured not even knowing it's going on and someone communicating with a business partner, not transferring funds out of its own account, so not computer fraud, not communicating with its bank, so not funds transfer fraud, and not having the insured actually transfer the fund as a result of being duped, so no social engineering fraud.
So there is two recent opinions in the scheme of, or in the realm of the classic reverse social engineering. And you got the POSCO case out in New Jersey from 2017, in which the insured's vendor sent funds to an account controlled by the bad actors. The insurer here immediately filed a motion to dismiss under Rule 12, and it was granted without prejudice, allowing the insured to amend its pleading, as the court found that the insured did not own, lease, or hold the funds that were transferred to the fraudsters. Those funds were owned by the vendor, not by the insured. The court said that it agrees with travelers that before the insured actually received the monies due, it owned a receivable or a right to payment, possibly even a tort cause of action for not receiving the payment, but that is separate from a first-party fidelity loss. So the insured then amended its pleading, and the insurer filed another motion to dismiss, which the court granted with prejudice. There were three new arguments raised by the insured that were expressly rejected. First, the insured said that it owned the funds because its vendor had taken the position that it does not owe the insured any more money, and the court said that doesn't control how policy language is interpreted. Second, the insured said that it owning a receivable qualifies as tangible property. The court dismissed that, saying that under the UCC and some other cases in our fidelity world, that a receivable is intangible property and is not what is intended to be covered by a bond or a crime policy. And finally, the insured argued that once the vendor placed the funds into its bank's funds transfer system, it had a right to impose a constructive trust over them and therefore owned them. And the court found that that argument was too far afield and ultimately held in favor of the insurer, finding that a traditional crime policy does not cover reverse social engineering.
So conclusion, takeaways for this. Crime or other fidelity policies, commercial crime policies, are not intended to cover the insured's inability to collect a receivable. I think this comes up again, obviously in the context of reverse social engineering, may come up in other contexts as well. But it's not what commercial crime policies are intended to cover. Second, as a matter of practice, when you think about a reverse social engineering claim, it's a social engineering claim to someone else. So potentially there is coverage out there. It just does not lie with the insured's commercial crime policy. It may lie with the entity that was tricked into sending the funds, and that's likely the best landing spot for this loss.
So in response to this scheme is becoming more common, and our insureds are submitting more claims with this, and they want coverage for it. Maybe its client vendor, as Matt just said, either won't pursue coverage under its own fidelity policy or doesn't have it. So I have seen there are some endorsements out there. I think that is an evolving issue for us. There are other potential coverages possible under cyber policies or even third-party cyber policies. So the industry is responding to this new risk and trying to meet the needs of its insureds.
Okay, and with that, that's our presentation on reverse social engineering. Thank you for listening.
Thank you.